So you really have to, so there's a lot of preposterous propositions, and I have sections on this in here, and you really double down on whether the defendant, we have all these, I don't understand why defendants in auto cases don't own up to what they do, but a lot of times they don't. I wasn't following too close, I wasn't going too fast, da-da-da-da. And what you say is, well, if you weren't going too fast, so you're going to drive that way when you go home today from this trial. You got to think about, so many times I see lawyers focused on their questions and focus on what they're not doing, what they're doing. They're not listening to what's coming from the stand. So make sure you listen from what's the stand and say, wait a minute, if that's true, think about what they do, and what I say, double down or judo on what they say. Well, if that's true, then such and such and
that's mine.
So and so. So always talk to doctors about money. When they're testifying on the other side for you, always talk to doctors about money, because you can always sit there and find out how much they made and how much they make testifying, and then you do the math and you add that up, and it becomes millions of dollars. I've done it in so many cases. So the defendants go to these doctors that testify all the time, and
retired Judge Anna Porter. Excuse me, go on.
I have examples of how to do this in here about talking to these doctors, and people are a little, oh, I don't want to get into their money, blah, blah, blah. You know, it's bias, and it shows that they're, I mean, the reality is that when these doctors are chosen, they are chosen because they have preset opinions that are conservative, and they're going to say your person's injury was because it was degenerative, it would have happened anything, and it's ridiculous. So you go after their money, you show the jury that they're bought and paid for, they've been doing a deposition a week for 20 years, you add up that money, you do the money real quick. And I've quickly gotten, if these people do it for years, you could quickly get them to the $1 Million Club, and you call them the $1 Million Man or $1 Million Woman in closing argument. And when you're doing a med mal case, you always want to talk to these doctors about what they remember apart from the medical records. Most of the time, they don't remember much, but they'll sit and they'll look for, and they'll testify later of their records like they remember all this stuff. So the first thing, one of the first little tricks I do, and I'm happy to share with you, is what do you, before we get in the medical records, what do you remember apart from this? Well, I remember their hair was black and what else do you remember? Well, I remember that. Is that all I remember? Yes. All right, you get them to say that's all they remember, and then you go on into the case, and then in the case when they're talking about this stuff, you say, well, that's just what you're, later on you go, well, that's just what you read, right? Yeah. You think you gave them that informed consent because it's signed here, right? And that's your usual custom and practice, right? Yes. But you don't personally remember that. Yes, that is correct. I have a case right now where the medical authorizations are signed, the informed consents have the time on them. And I sat, before I was going to go depose the doctor, I went and looked at the time. On every consent, it's 5 to 20 minutes after the procedure and after it was dictated on the electronic record. So how is that informed consent if they're writing it later, right? So he did not have any memory of that, didn't know that, couldn't do that. So do that. Look for, two, it's the last point, is all the time, when you go depose these defense doctors, get their file and look through it and mark the letter where the lawyer sent him the case, because it happens all the time. They tell the doctor what his opinion's ultimately going to be. I give you a transcript at the end where the lawyer did the disclosure, handed the disclosure to the doctor, and he read it and testified about it. And I was like, you just read your opinions, that's what the lawyer wrote, right? Yeah. Or when they transmit the records. On the concomitantly, I'll tell you what that means later, Bob. On the other hand, when you hire a doctor, don't write him a letter and tell him what he wants to see. In a med mal case, all I ever do is say, doctor, enclose please find medical records for your review. Here's a retainer check. Once you reviewed them, give me a call, right? You don't want to put any of that in writing, and you don't want to be editing their opinions or their reports in writing as well.
You just talk to them on the phone.
Yeah, exactly.
Okay, yes. So actually we're about finished.
We're done.
We're done.
Anything
we're
else?
Done. I just wanted to say that, again from Judge Wallace, she says, we all might dress alike, but we are different. So know your judge to a certain extent as to what their practice is. Be nice to the clerk. You'll learn a lot about the clerk. And do not say, with all due respect to a judge,
This is
because
the
they'll
best.
think that you're saying you're an idiot.
Don't say with all due respect.
With all due respect, what does that say? With all due respect, you idiot. Okay.
Is Judge okay?
I think judge is okay.
And the only thing is, don't make negative facial expressions or comments or talking among yourselves or making a comment to your associate while you're in trial. It's bad and it can be heard many times.